Woo! Good afternoon, people. Oh my goodness. Wow. Good to see you guys. Man, oh, coffee, shut up. Okay, I guess my coffee's gonna make noise while I'm getting ready to read this article here, which I'm trying to do without pop-ups. Give me 1 second here. And yeah, I just got to reset my password because I can't remember it. Sorry, give me 1 second here. Hopefully this is okay. Let me just sign in here. I thought it was going to keep me sign in, but it didn't. Yes, save. All right, there we go. So I'm trying to avoid the pop-ups. Okay, so we're good. Anyway, guys, thanks for waiting. Thanks for your patience. I appreciate it. It's great to see you guys. And for anything that I missed, hold on 1 second. I think, wait, what? Oh my God. Wait, what?
Oh, here we go. Yes.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat. I think we got a super chat. I think we got.
Okay, so the super chat song and dance has been updated. Listen, here's the explanation behind that. That's for Sean. Sean, I refuse to make you out to be this super villain that everyone's making you out to be. I don't think that there's going to be any validity to any of the shit you're trying to pull. And so to me at this point, you're just a fucking joke. So congratulations. Your stupidity has now taken a back seat to Ryan Upchurch's stupidity. Congratulations. Oh my God, not again.
Oh, here we go. Yes.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat.
My God. Oh my God, too much. Oh, but wait, not again.
Oh, here we go. Yes.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat.
Oh my God. Listen, man, I gotta have reasons to chuckle. I gotta have reasons to chuckle. Not again. What?
Oh, here we go. Yes.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. we got a super chat. I think we got a super chat. I think we got.
Okay, wow. You guys are you guys are too much. All right, last one.
Oh, here we go.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat. I think we got a super chat.
All right, I have to draw the line somewhere, Emily O. Otherwise we'll never get through this. So I'm just gonna let Turtleboy's article speak for itself. I'm gonna go ahead and read it. But as the title says, Mark Bederow has made good on his third letter, which Turtleboy will explain in his article here. I have not read it yet, but you guys know how I like to do reactions, and I figured as I was going to read it, I'll just hang out with you guys in the process. So like, wow.
Oh, here we go.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat.
Okay, so, and I have to credit, and I feel really bad because I forgot the handle on Twitter, and it's somebody who I interact with quite a bit. So I'm just having a brain fart. But somebody I asked them specifically if they could send that to me in a file, and they did. And that was exactly what my intention was. And so thank you for that. So now this is now officially the super chat dance. It is the new upgrade of the super chat dance. That is what will happen whenever I play the super chat dance. No, okay, listen. No. Listen. We gotta we have to limit this to some degree here. We have to limit this to some degree. Okay? It has to be done. Even though I never get sick of it. It has to be done. I will get on with them more later on as we progress, but oh my God, Jesus. Okay. All right, last one for a while.
Oh, here we go.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat.
Oh my God, dude. Oh my God, this is just too fun, dude. This is just the funnest shit in the world. Oh my God. Let me exit out of this shit right here real quick. Hold on. Let me share what I got going on here. Oh, Cherry, don't be such a scrub. So, Canton cover up part 445. Turtleboy defense team file rule 17 motion for Michael Morrissey's private email account used for ex parte communications with judges. So Turtleboy writes here, the Turtleboy legal defense team, and for those of you who haven't noticed, Turtleboy's defense donation link is linked to the top of the chat. If you're feeling generous, please help him out because apparent now he's got a whole new fucking monster of stupidity going after him now. So yeah, so he's gonna need all the help he can get. And Glare is my boyfriend. Thank you, Buzzy for Truth. For Catnip Toys for Drago, thank you so much. Appreciate it. The Turtleboy legal defense team has filed a Rule 17 motion in Norfolk Superior Court asking for access to Michael Morrissey's private email account that he used to communicate with judges ex parte about Turtleboy's activism on September 29th, 2023. It says here, defendant's motion to compel Rule 14 discovery and for issuance of Rule 17 summons. Now comes Mr. Aiden Carney, defendant herein, and respectfully request that the court order the prosecution of statements referenced herein below and further advise the clerk magistrate to issue a mass blah, 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 blah summons to Apple Incorporated via email as requested by Apple to law enforcement at apple.com. The designated address for court orders for 1, any and all emails or text messages sent or received beginning on August 10th, 2023 to present associated with the Apple iPhone and or iCloud account assigned to private subscriber Michael Morrissey. Norfolk County District Attorney, the subscriber, be provided subscriber's personal email address to be provided under separate cover to be filed under preliminary impoundment subject to court's order. Further, the Norfolk Superior Court's clerk's office receive and retain the information under impoundment. So they're going straight to Apple. They're trying to get a motion granted to where this is a motion filing to where they can obtain all of Morrissey's bullshit from his private account via Apple. And they just want to go through Apple. So now it all depends on whether or not the judge will approve any of this. Now, I don't see why they wouldn't, considering the proof that they plan on bringing. So hopefully, but then again, if you get another Judge Bev, then you got a problem. But not necessarily, because even if that's the case, Bederow and Bradel can still call Morrissey to the stand. And then it'll be up to a jury no matter what. So this, whether this is approved or not, it makes a difference, but at the same time, it's not a killer. You know what I mean? It's still good for Turtleboy and Bederow and Bradel. As discussed in part 3 of the Bederow letters, we discovered through a whistleblower that Morrissey used a personal iCloud email account to communicate with several judges on September 29th, 2023, including Stoughton District Court Judge Daniel O'Malley, who denied a harassment prevention order for Chris Albert against Turtleboy the day before September 28th, 2023. The day before, which was September 28th, 2023. He wrote the email after Jen McCabe contacted someone in law enforcement, unknown who, and demanded that the Stoughton District Court employee who sent me a copy of Albert's public affidavit and here after David from early June be identified. Morrissey did as he was told by McCabe and gave the name of a woman he suspected was the employee they were looking for. 2 weeks later, I was arrested and Judge O'Malley issued 8 stay-away orders preventing me from coming within 500 feet of witnesses, including Chris Albert and Jennifer McCabe. Pretty interesting how that works, isn't it? Trooper Proctor said he had no close personal relationship with any of the parties. Changed my mind. It's got all this proof, all these receipts. It's a great meme. Morrissey is not allowed to use a private email account to conduct government business. He knows that public records laws allow the public to read communications between public officials on matters of public concern, but he didn't want the public to know that he was directing several judges to punish me for my journalism in regard to the Karen Reed case, which is why he used a private email account. Oh, and Tom Gillis. Oh my God.
Oh, here we go. Yeah.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat.
Thank you, Tom Gillis. Appreciate you, buddy. Oh my God. Morrissey is not allowed. Oh, yeah, I already read that. So here, this is the email from Michael Morrissey from his little iCloud account, from his personal little iCloud account to Stacey Fortes, a judge. Dear Judge Fortes, I am writing to express my, sorry, got to do it in Morrissey voice. Dear Judge Fortes, I'm writing to express my grave concern with actions taken by an individual employed at the Stoughton District Court in regard to an affidavit that was shared with a blogger writing about an ongoing second-degree murder case. On September 28, 2023, a witness in the Commonwealth versus Reed murder case, that's R-E-E-D murder case, filed a request for an application for harassment prevention order, which was heard before Judge O'Malley. The application and affidavit were processed in the Civil Clerk Department of Stoughton District Court and presented to the judge, which after hearing was denied. We are informed by the witness and others that shortly after the hearing that Aiden Connie, aka Turtleboy, was provided with a copy of the entire affidavit. There is no way that he would have been aware of the proceedings without an insider working in the courthouse. This needs to stop. The leading individual who presents a possible leak is Michelle Littlefield. That's Littlefield. Michelle Littlefield. And she needs to be stopped. Then there's this here. I know it's late, but I am horrified that Chris didn't get it. This is from Jen McCabe here. I know it's late, but I am horrified that Chris didn't get it. And I'm even more disgusted that for the second time, someone from the court leaked it right away to TB. Then because the people who work in Stoughton District Court like me more than him, they sent this humiliating affidavit to me so we could shame him some more. We put in a request for the court audio, and hopefully, with a little luck, we'll have it for the live show on Sunday. Clarence Woods Emerson, that's also Turtleboy. Dear Chris Albert, I know what you did today. Blog coming soon. And then a Turtleboy post here says, Chris Albert applied for an order against me today in court. And this is obviously the 23rd, and was denied. And his affidavit is the funniest thing I've ever read, funnier than Jen McCabe's. All this because I peacefully protested at the Board of Selectmen meeting, and that's where he was holding a sign next to Chris Albert that stated, if I remember correctly, Chris Albert killed a man with an arrow pointing at Chris Albert. Oh my God. Turtleboy are attached. It's clear from the posting that Stoughton Court is directly involved in this dissemination of information affecting our murder prosecution. From the comments from one of the witnesses, you can see that they have completely lost all confidence in the courts of the Commonwealth. I have to agree that the actions erode the trust and integrity between the courts and the public and the relationship with the district attorney's office. We are extremely concerned. Oh, I should be doing this in Morrissey voice. I'll just start over. It's clear from the postings that Stoughton Court is directly involved in this dissemination of information affecting our murder prosecution. From the comments from one of the witnesses, you can see that they have completely lost all confidence in the courts of the Commonwealth. I have to agree that the actions erode the trust and integrity between the courts and the public and the relationship with the district attorney's office. We are extremely concerned that the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and damage to a witness in an ongoing homicide prosecution, must be a violation of court policies or potential violation of law, and it needs to stop. We also understand that Aiden Kearney had also immediately requested copies of the FTR record that was made on 9/28/23. Again, there is no way that he would have or should have known that hearing took place. There are a number of concerns that we have about the possibility of having file ongoing motions or other requests for warrants before this court that will affect the orderly and fair administration of justice. These actions are completely unacceptable and must be resolved immediately and need to stop. I understand that you have to do an investigation and that may take time, but you also have to provide us with some evidence and assurance that you have taken action so we can safely continue to use the clerk's office of the Stoughton District Court. We have a number of delicate matters before them on a day-to-day basis. I await your advice. Michael W. Morrissey, District Attorney. In the motion, we demand all emails or text messages associated with Morrissey's iCloud account. I love that shit. Now comes Mr. Aiden Carney, defendant herein, and respectfully request that the court order the production of statements referenced here and below and further authorize the clerk magistrate to issue a mass criminal blah, 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 via email as requested by Apple, the designated address and apple.com, blah, 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 for any and all emails or text messages sent or receiving beginning on August 10th, 2023 to the present associated with the Apple iPhone and or iCloud account assigned to private subscriber Michael Morrissey. Norfolk County District Attorney, the subscriber, be provided subscriber's personal email address to be provided under separate cover to be filed under preliminary impoundment subject to court's order. Further, the Norfolk Superior Court Clerk's Office received and retained the information under impoundment. Turtleboy goes on to say here, we agree to have a special master go through his account and pull out any discoverable communications, including emails he sent to witnesses, alleged victims, and law enforcement. We also want any emails he sent about me personally. Morrissey cannot be trusted to turn over this information on his own. Number 3, further, that the court appoint a special master independent from, but at the expense of the Norfolk County District Attorney to review the content provided to the court and provide to the parties all Rule 14 discoverable statements. A, among the subscriber and any civilian witnesses or law enforcement witnesses or alleged victims, and B, any ex parte statements to the judiciary concerning the defendant herein and or any other witnesses or person connected to the defense of the above captioned cases or the pending case in Dedham District Court involving the same complainant. And 4, that DA Morrissey be personally ordered to provide any other Rule 14 discovery in his possession, custody, or control, whether on paper, storage devices, personal or office devices, and whether situated, including but not limited to the readable, accessible, full extraction from Mr. Carney's phone referenced in the communications. So translation, basically, we want literally everything that Michael Morrissey has ever said in regards to Aiden Carney to anyone, and we don't give a fuck who it is. We want every bit of communication that this guy had in regards to discussing my client, Aiden Carney, aka Turtleboy. I want to know who he was talking to, what was being said in regards to my client, because now it is all discoverable. And I love that shit because Bederow is the man. As grounds, the defendant states the subscriber Morrissey is the chief law enforcement officer of Norfolk County and the ultimate authority over all Norfolk County assistant prosecutors, whether designated assistant or special assistant district attorneys. As such, he is part of and, in fact, the leader of the prosecution teams in the above captioned matters. I love that this is being put out there like this. In caption matters, ethically prohibited like any other attorney from engaging in ex parte communications with justices on pending matters. Likewise, and equally axiomatic, any written or substantially verbatim recorded statements he receives or participates in from civilian or police witnesses or alleged victims are statements that must be disclosed to the defense under Rule 14 of the Massachusetts Rules of Criminal Procedure. So basically, they're saying it's basically against the law for Michael Morrissey to be talking about Turtleboy in an ex parte fashion with anybody outside of the case. There should be nobody that he's talking to outside of the actual open case that he's talking to about this. So he's breaking the law, which makes him subject to all of those communications being discoverable. So Morrissey's basically fucked here. Right now, Morrissey's shitting in his pants, in his fucking 64 waist fucking pants. Here, the defense team has received and publicly shared whistleblower information that DA Morrissey has personally communicated in an ex parte fashion with the then Chief Justice of the District Court, the then presiding Justice of the Stoughton District Court, and other high-level court personnel, disparaging the defendant therein. Though the use of private burner email account with the obvious intent to avoid scrutiny from the public through public records requests. Yes, exactly. See, blah, 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 October 17th, 2024 letter to Special Prosecutor Cosgrove from co-counsel Bederow, attached hereto in its entirety as Exhibit A. DA Morrissey's communication to the court personnel also contained a screenshot of a partial communication, i.e. Rule 14 discoverable statement, from an alleged victim listed in one of the indictments against Mr. Carney, alleged victim. Fake. DA Morrissey complaining about leaks of public information to defendant Carney, according to a number of witnesses in this matter, and depending one such statement in his personal possession in the ex parte communication. Morrissey's illicit communication literally solicits responses from the justices and refers to additional statements, justifying the defense inquiry for further documents and communications. Fucking love this shit. And then, I guess it was Bredel that wrote this out. And Turtleboy says, as attorney Bredel pointed out, the whole purpose of using the private email account was to evade public records requests. This was a scheme to avoid having over discoverable evidence, including communications with the same judge who arraigned me 13 days after receiving the email from Bredel. So that's fascinating. I mean, the timing is a little bit of a coinky-dink, no? It's a little weird, isn't it? It's a little weird. Oh, sweet. Okay. So he uses a personal email account, right? Clearly to avoid records, avoid the little hiccup of records requests, to dodge that bullet, so he could pull shady shit from behind the scenes. And now you match that with what Turtleboy knows about Tully, with what he knows about Kate Peter, with what he knows about Lindsay Gattani. You take all of these things and put them into perspective, and all of the timeline. If you're trying to build a timeline for a fucking frame up, it lines up, it tracks, it just simply does. And he's laying it out here right now. To the extent of District Morrissey or his agents have gathered such undisclosed statements from a number of witnesses and or communicate with such persons on their personal devices, the entirety of such statements are discoverable under Rule 14, and the use of a personal device does not sanitize those communications from discovery. Appeals court noting and leaving undisturbed successful requests for agency employees' personal cell phone usage where public matters discussed. Further, the plain language of Rule 14 makes no distinctions as to the locations of discoverable statements and is focused instead on their possession, custody, or control. So that it means it doesn't fucking matter. Like, it doesn't matter about the locations, about where they are, where they're found. It doesn't matter what devices they're found on. It matters as far as who is in possession and in control of this data, of these communications. So it doesn't matter. They can search laptops, they could search phones, they could search whatever the fuck they want. If it's in possession of Michael Morrissey, then it's subject. If a prosecutor brings a written statement of a medical examiner's paper copy of a report home from the office, it does not change the equation. And as we evolve into the digital age, their choice to receive, create, and store statements with witnesses or other discovery on their personal electronics equally carries no weight as far as Rule 14 is concerned. Instead, the court should be focused on the obvious attempt to elude discovery obligations, sanction such actors when discovered, and make broad findings and pronouncements that such communications must be routinely disclosed, and when they are not, sanctions will be applied. So Michael Morrissey not being candid with these things has made him subject to them being seized, to them being searched. The public, or the people, let's just say, have a right. Turtleboy has a right. Turtleboy has rights. So if this dude is doing some backhanded shit behind the scenes, Turtleboy has a right to know about it because his rights are being violated. He has a right to know about it because it could be used as evidence that could exonerate him. And Turtleboy has every right to a legitimate defense as much as anyone else. And this constitutes as being under a legitimate defense. It is not unreasonable to ask these things of Michael Morrissey when Michael Morrissey, the district attorney of Norfolk County, knows the rules. The district attorney of Norfolk County understands that what he needs to do, anything that is in the practice of conducting business, as far as an open case goes, must be used through his Norfolk County, his official Norfolk County DA email, not through his burner bullshit. Because everything is discoverable. Any discussion on Turtleboy's case is discoverable. So now, since Morrissey fucked up, and we get to see that if a judge orders it, if a judge decides to rule in Turtleboy's favor here, if that happens, I get wet just thinking about what else is in there. I mean, I just get sloppy thinking about what is possibly in those devices in regards to the Karen Reed case, in regards to the Sandra Birchmore case, and so on, and so forth. DA Morrissey's ex parte communication was a complaint to the presiding judge sitting on Mr. Carney's case, attributing negative conduct to Mr. Carney's on a private email. This knowing and willful violation begs the question whether they were equally discoverable responses from the judiciary, and if so, did Morrissey cover them up or delete them? The other obvious issue raised is whether there are other discoverable communications memorialized and hidden away on his personal devices. Where DA Morrissey obviously engaged in a scheme to avoid discovery and public record scrutiny of his attempt to influence justices against Mr. Carney, he cannot now be trusted to simply agree and comply with the court's order to provide all such communications when he has already been caught. He has displayed brazen proclivity to skirt public records and discovery rules. As such, he has shed himself of any presumption of compliance with the rules. The appointment of a special master to ensure compliance with a strong and broad discovery order is appropriate in these circumstances. People, that right there is what we like to refer to as spicy bread. And I see Microdots is in the house. Good to see you, buddy. Oh, this is just beautiful. This is just beautiful. Because here's the thing, folks, is you have to understand why this is the dopest shit in the world. Because if Turtleboy, of all people, by the way, if Turtleboy ends up proving through his case that he didn't ask for, they went after him. If he ends up proving through his case, because through his case, he was able to obtain Michael Morrissey's devices to get searched through, that means to find out, I'm talking celebrate, to find out if shit was deleted, when it was deleted, who he was in communication with, when those things were deleted. When that shit happens, can you imagine the shitstorm that's going to cause in the Karen Reed case? Can you imagine possibly what this could do for all of Michael Morrissey's corruption that his umbrella of corruption covers? I mean, I'm telling you, Bradle and Bederow, the killer bees, they just metaphorically set fire to the Norfolk County DA's office. Like they poured gas on it and fucking lit the match. Just went, all right, let's see what happens here. It's beautiful. It's fucking beautiful. Where DA Morrissey obviously engaged in a scheme to avoid discovery and public record scrutiny of his attempt to influence justices against Mr. Carney, he cannot now be trusted to simply agree and comply with the court's order to provide all such communications when he has already been caught. I already read all this. I'm sorry. The Lamprin case has set the standard for Rule 17 motions, and the hardest obstacle to overcome is the fourth provision, which states the applications must not be a fishing expedition. That's a good point. So Turtleboy was pointing out that they also have to prove that this is not just a fishing expedition here. Before ordering that the summons issue for such records, a judge hearing a Rule 17 motion must evaluate whether the Lampron requirements of relevance, admissibility, necessity, and specificity have been met. Commonwealth versus Dwyer. Specifically, Rule 17 requires that the party moving to subpoena documents to be produced before the trial must establish good cause, satisfied by showing 1, that the documents are evidentiary and relevant, 2, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence. 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial, and that the application is made in good faith and is not intended as a general fishing expedition. Now, before I continue, guys, let me do this. I want to share. I'm going to go ahead and share the link of what I'm reading in chat. Now, I realized realistically that most of you are already subscribed to Turtleboy Daily News. If you're not, consider doing so, because obviously this right here is what you get. And this is a great example of what you get. You get the truth. You get receipts. You get the first to know. I mean, Aiden being completely and totally involved in this case now puts him in a position that no other journalist may have ever been in, which is fascinating. So everything that he's putting out here is he's first to do, because he's not only witnessing it, he's experiencing it firsthand. So be a part of history here, folks. And I would highly recommend subscribing to Turtleboy Daily News and making sure to read this for yourself. Now it says here, 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And 4, that the application is made in good faith and not and is not intended as a general fishing expedition. Now that is quoting Commonwealth versus Dwyer and United States versus Nixon. We can't just ask for everyone's phones without having good faith basis to believe that there is exculpatory evidence within those phones, which we all, not only do we believe that there is exculpatory evidence within those phones, folks, as Turtleboy's claiming here, not only do we believe it, but I think it's safe to say that the majority of us, our better instincts dictate that there are. We know in our hearts, we know in our balls and in our bones that there is exculpatory evidence in those devices. I mean, just look at everything that we already know. It would be naive, and that's putting it nicely. It would be naive to assume that there is, or to even question that there would be exculpatory evidence in those devices belonging to Michael Morrissey. If they're in anybody's devices, they're in his. Guaranteed. Turtleboy goes on to say, but since we have evidence that Morrissey has used this account to secretly conduct ex parte communications with judges in my case, we have met that requirement that they have. The Bredel goes on to say in this motion, here the statements and discoveries sought are potentially exculpatory and reasonably expected to provide evidence shedding light on prosecution bias and improper ex parte communications, prejudicing Mr. Carney to the court. Where D.A. Morrissey personally possessed and used witness statements in order for him to personally provide all such undisclosed statements is warranted. In the circumstances, the defense is amply justified in asking for any and all information concerning statements and ex parte communications from the involved parties for cross-examination. All relevant, powerful exculpatory evidence. The information in the records is not obtainable in any alternative, trustworthy, and admissible manner. And prior inspection is necessary for a fair trial. The information request is based on the personal knowledge of the undersigned after viewing the aforementioned whistleblower information attached here too. Finally, The records sought are not a general fishing expedition into immaterial areas. See the Commonwealth versus Lamprin. Setting forth requirements for summons for third-party records. Rather, the bias and potential bad faith of investigators and the collusion with witnesses for improper purposes is always relevant and admissible. For the foregoing reasons, the defendant asked the court to authorize the clerk magistrate to issue a Rule 17 subpoena compelling the production of the records as listed above for entry of Rule 14 order as requested, respectfully submitted by Aiden Carney, defendant by his attorney, Timothy J. Bradel. And there it is. That's it right there, folks. Well, let me see what we got here. Hold on. I mean,
Oh, here we go. Yeah.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat.
Thank you so much, JoJo. Thank you for all you do. I'm from the cesspool of Norfolk County, and we love you. I love you guys too. I really do. SD, thank you so much. It's SD, not Etsy. Needed to see the new super chat song again. Well, since you requested.
Oh, here we go. Yeah.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat. I think we got a super chat. I think we got a.
Oh my God. And then you got Biatch 414. Thank you so much. Hopefully there are no nudes on his phone. Ugh. Yikes. Don't you put that evil on me, Biatch 414. Won't you put that evil on me? Grand's Pants, truth is like poetry, and most people hate poetry. Good point. That's actually true. I've heard that before, though. Wow. People, I haven't even been live an hour. I mean, think about this. Yeah, listen, I'm not gonna be like, I'm telling you, like, I'm not gonna do anything except like if I talk about Sean, it's just to point out the clown that he is, dude. At this point, like, this is not a serious person. This is not a person that is he a threat in the sense that he's trying to take Aiden down? Yes. But what he has is silly when you think about it. It's easily fought and it's easily disproven and it's ridiculous and it's clearly a witch hunt. So I am not worried about it. I don't take it lightly. I think it's fucked up what he's doing, but at the same time, I'm saying that it's bullshit and I wouldn't worry about it. And I'm not going to give him the power of worrying about it. Tim Bell, thank you so much. No song necessary. Great show. Thank you so much. I appreciate it. But I'll be goddamned if I'm not gonna like point out the fucking humor in how fucking silly this dude is. Like, he's now Plevin level stupid, you know? I mean, what else are you gonna do? Let me explain something here. Okay. The Glarer, please stop mocking Sean. I don't think people within the Karen Reed movement need to go after each other. Be the bigger person here, please, and don't play the small-minded nonsense. First of all, I don't know if you're new to the channel, but I'm small-minded as fuck, and I'm petty as fuck. A. B, I'm going to do whatever the fuck I want to do here. And C, you're saying don't stop mocking Sean and this is blah blah blah. No, okay, understand something. He has gone against the Free Karen Reed movement because he is now actively trying to get Karen Reed locked up. Why don't people understand this? So now, do I think he's going to pull it off? No, I don't. But I'm damn sure not going to sit here and act like that's not what he's doing. And I'm damn sure not going to sit here and act like the community is fucking split. No, the community's not split. This dude turned his back on everyone here who has been busting their ass trying to get national attention on this by simply showing evidence. And then this asshole comes along, decides to get petty and make it a competition between him and Aiden. And the only reason it's a big deal is because he claims to be a former DEA agent. So that gives him a little so fuck Sean. Fuck him. Now, I don't think he's anything to worry about, but he's definitely something to make fun of. Fuck him. He's earned it. And you're not going to fucking shame me and make me out to be like I'm not being the bigger person. I actually am. Because if I'm going to make fun of Plevin for doing what he's doing, and Sean is acting the exact same way, then Sean is subject to the same criticism and subject to the same satire, subject to the same parody. He's subject to all of it. Same as Kate Peter, same as anybody else. So I'm not going to be made out to be the bad guy here because this is how I choose to cope with this asshole shitting all over everything that we've done here for the past year. Fuck Sean. Now, I respect your feelings. And I don't mean to be mean to you specifically, because I get that you're just trying to get everybody to get along here, but Sean turned his back on everybody here. And if you choose not to see that, that's your business. But I'm not going to be shamed by running my show the way that I choose to run my show. I'm just merely defending myself against your comment. So, but you're welcome here. I'm not mad at you, but I have a right to express myself based on the things that you're saying because you got me fucking wrong. Yeah, like I don't even care that he's on another live. I don't even care. It's like I there's nothing that he says anymore that has any validity to it. That's just what it boils down to. Sorry. There was one other thing that I wanted to go over here. Hold on. No, not that. No, not that. No, not that. All right. For today, for the latest check. Now, I do like to see even though I don't invest much into it, I do like to see what Court TV is saying. So let me show this. I haven't gone over this yet, but this is their latest little piece here, and Vinnie Politan doesn't seem to be there, and neither does Julie Grant. So this is one of those situations where I'm like, come on, Court TV.
Chapter in the Karen Reed saga. As her January retrial date quickly approaches, Reed and her attorneys were back in court today for a series of motions, including a request to postpone her retrial until April. Now, earlier this month, the Massachusetts Supreme Court heard arguments from her attorneys asking for the top charges to be dismissed in the death of her Boston police officer boyfriend on the basis of double jeopardy. Now, Reed is accused of backing her SUV into John O'Keefe and then leaving him to die on a snowy road in 2022.
I already don't like this guy, but let's see.
She claims that she was framed.
It's that I don't like his tone. She claims
A widespread cover-up by law enforcement. Well, at today's hearing, both the state and the defense argued a number of motions, including a Commonwealth motion for Verizon cell phone records and a defense motion to unseal sidebar conferences from the first trial for the lawyers only to use so that the Commonwealth's new prosecutor could get up to speed. Also at issue was prosecutors notifying the court they intend to reassemble and retest the black box and infotainment system in Karen Reed's Lexus. So let's go in now and listen to some of those arguments.
The Commonwealth tested information on
the Commonwealth tested the information.
Data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert. And in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information, information regarding phones that were plugged into the radio.
Okay, sorry. I just remembered who it was who provided me with that clip for the super chat dance. That was RG Larry Legend on Twitter. So big shout out to him. I just wanted to, because I would feel like a dick if I did credit him for this. It's very kind of him to send me that in a file so I could make that.
The radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader. So that why the information was not available.
Okay, shut up for a second. Yeah, I mean, look, dude, it speaks volumes. You know, it speaks volumes. I mean, this, if you want drama, you know where to go. That's it.
Also, in the telematics, the infotainment system, there were actually 3 boards, not one. Only one was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case. And so we provided notice to the defense that our intention is that we are going to.
This is interesting because during grand jury testimony, Proctor testified that Guarino submitted a report stating that he could not retrieve any data from the infotainment system from Karen Reed's vehicle. He could not retrieve any data, but concluded that his opinion was that John O'Keefe was the victim of vehicular homicide. Explain that shit.
Going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission. Rather, it was to notice them. This is what we were going to do. You can see from my motion, I asked to do it within 14 days.
Blessed are the clip channels, Nikki.
Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they're entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date.
Yeah, and listen, that's Turtleboy's right. Okay? I want to be very clear. This is beef between him and Sean. That's Turtleboy's right to address and defend himself against Sean's bullshit. But I don't have any skin in that game. All I have, I can only do what I have skin in the game for, which is the shit that I've put into this case. And to me, he's just a joke. That's it. And I'm going to treat him like a joke from now on. Period. But, you know, what he's doing to Turtleboy has a right to have personal feelings about it and address it. And I will be there in Turtleboy's chat to support him for it too. But, I mean, I'm not going to sit here and make it my shit, you know? What is my shit is that. Turned his back on truth and justice. That's a fact. That's my beef.
Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them. And so I've spoken to the defense. I know they've hired an expert. I know they've filed a motion contesting our position. I'm not going to speak for what their position is today. But I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they want, but we're entitled to the download. Notably, when the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility. But it was the defense expert that overlooked the proper reader that was needed for the chips that were tested. And it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights. And that's why.
Okay, smartass. Let's see what this mystery's all about.
Oh, here we go. Yeah.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat.
Mr. Monk's understudy, thank you. Any chance we can watch Auntie Deb's newest video with you at end today? If I can remember, I will. If I do, don't let me forget to share the link so that you guys can give it all a like and everything. Yeah, Auntie Deb is just great. Make sure to subscribe to Auntie Deb if you're not already, like regardless of whether I go over it or not.
That's why we now have an independent expert that is going to do this. I know experts differ. They're not frick-a-frack. They all have different opinions. But we've attached all of the protocol, what we intend on doing. And the reason I brought it before the court I wanted to expedite this matter. It's important, and it does.
I thought we were going to have that hearing within 14 days when we first got the motion. And then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then. But as of right now, it's still January 27th. So all of these things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, 'cause it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
how long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to. But they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay, I'll hear you, Mr. Jackson.
Go flip ahead.
Thank you, Your Honor. I'll start by saying, in principle, we don't have an objection to the retesting of the telematics or the infotainment center or system data. The problem that we have, or our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find.
You can't take a red eye, Mr. Jackson.
Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip off, physically did not know how to do it. It was Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former MSP officer and extremely facile in this world.
And you have a different expert now. You're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip offs and chip ons. That physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure. He knows how to do it. He's got an extremely long resume, having done this kind of work.
I read it.
We're bringing him up to speed in order to sort of engage in some oversight and some observation. Okay. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2-micron chips and the Spansion chip that he looked at. Didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Burla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips. That didn't exist when Ms. Gaffney did her work previously. She put it on a reader, it was unreadable.
Alan Jackson, such a great attorney. He's already disparaging the state's expert. It's amazing. Great stuff. All right, we're going to hit the pause button.
Okay, I'm starting to like this guy.
Right here. We're going to take a quick break, but when we come back, the prosecutor pushes back on the defense's request to work with the Commonwealth's expert and oversee the handling of the vehicle computer chips. So keep it here on Court TV, your front row seat to justice.
My man was like, Jackson's such a good attorney. Great stuff.
We're at all. Anna Gabrielle Higgins. Before we head back to court, let's bring in our guests for this hour. Joining us, trial attorney, former public defender Gabrielle Higgins, also criminal defense attorney, former prosecutor Joe Tamburino. Great to see you both. Thank you so much for joining me tonight on the program. Gabrielle, I'll begin with you. I thought in the first trial, one of the weakest areas for the state was this accident reconstruction part. They just brought in a police officer who kind of put some stuff together. They're claiming that the information they really needed was kind of messed up by the defense's expert. Sounds like they plan to bolster that part of their case. What do you make of what we heard so far?
I think that digital systems, specifically an infotainment system, are typically very volatile. And so you heard a lot of this in the hearing, that if you have a limited understanding, like they claim the state's expert had a limited understanding of infotainment systems, then not only is the analysis.
Well, why do they exist then? Shouldn't these infotainment systems be pretty fucking durable? Aren't they designed, like, in case of an accident, they record the situation to some degree, like the data from the car? Like, why not? That's weird. Why are they volatile?
Is faulty, but there's a risk that the actual data was mishandled and as a result, likely not preserved. Typically, the absence of information lends itself more favorably to the defense. And so it's in the defense's best interest to say that, yeah, this data was not only analyzed, but it was mishandled and it was missing. And that's really the state's burden. That's not really our problem. The state's trying to shift that burden in a way that I don't think is going to be successful.
Joe, I got to ask you, it sounds like they want to have their expert there to kind of oversee what's going on because they don't trust or don't have confidence in the expert that's being used by the state. I thought it was brilliant by Alan Jackson. He knows these things are televised. He gets it out there that, we don't have confidence in their expert. But more importantly, could it be possible? Now, the way it was laid out, only about a third of the information that was on the black box and infotainment system was available in the last trial. Now, if we get all of it, is it possible that we could get the answers we've been looking for? What actually happened? How fast the car was going? Did it back up? Did it make that U-turn? Et cetera, et cetera.
I mean, I will agree with the trolls on one thing. I don't have a problem with the data being recovered. I have a problem with the risk of dirty cops and a dirty DA sticking his dirty little fingers in this data. That's my fear. But I don't have an issue with what I believe the data would reveal now. The problem is that and that's and that's what it sounds like the defense is on the same page there. The defense is basically saying we just want to have our expert kind of babysit, sit in while they retrieve the data. Because we don't trust. I mean, he didn't say it out there. He didn't say it outright. But basically, he's saying, I don't fucking trust anything that this fucking Commonwealth is doing, dude. This shouldn't even be retried. This shouldn't have been tried in the first place. I don't trust a fucking thing that any expert hired by the Commonwealth is going to do. I mean, I don't. Right. Microdots. Why would we doubt that? You know what I mean? Why would we think anything else? I was in the courtroom for the inverted video, dude. I saw that shit happen. Like, I watched the jury. I was like, dude, holy shit. And I'm trying to tell you that anything that comes from this Commonwealth, the trolls are like, well, why would you be afraid? And I'm here to just genuinely and not sarcastically, not in an aggressive or attacking manner. I will answer that question. Why are we afraid of them going over this new data? Or I don't like using the word new data because that's exactly the problem. I don't trust the Commonwealth. It's that simple. I have every reason. Even they can't argue with that. Even the trolls cannot argue with that. If any troll argues with the fact that the credibility coming from the Commonwealth is completely fucked, well, then they're clearly biased and they're clearly just like blatantly, willfully ignorant. There's nothing about the Commonwealth and how they've conducted this investigation or that first trial that makes me think, oh, well, I trust the Commonwealth this second time around. That's insane. That's insane. Why would I do that?
Yes, and Michael, what you point out is a really good thing that happened in the first trial, which is the prosecution's case not that it fell apart, but it had some challenges. And one of the challenges was the accident reconstruction. And so by doing a new reconstruction, you're quite right, we might get answers to this. And I have absolutely no problem with what the defense asked, which is to have their expert review this or look over the state's expert as they do the reconstruction, as they get the materials together. And that's quite common. I mean, many times you will have a defense expert go and view something that a state's expert is doing. So I think they're doing the right thing.
Gabriella, I want to go back to you quickly because you mentioned that this type of information can be volatile. Let's check back and know what you mean by that with your experience with this type of information. When you say volatile, what do you mean?
Okay, I guess she meant the information and not the actual data.
I think there were mentions of the chip on and the
like the data,
chip off
the data board is what I thought that she meant.
System. So when you're dealing with the chip on system, you're talking about the actual chip that's in the vehicle itself that contains the data. So when you're dealing with different power sources, when you're analyzing the data on those chips, some of that data could be lost in the process of trying to.
Now, Buzzing for Truth is asking a great question. She's saying, why aren't they bringing up the FBI? Now, if I'm playing devil's advocate for Court TV, I'm saying that they're not bringing up the FBI simply because it's a new trial and the FBI hasn't been brought up in the new trial. So, I mean, it's fair to leave it out for now, I guess, if you're Court TV, but it's going to come up. It's just a matter of time. It's going to come up.
Extract the information that you're looking for. That process requires an expert that's not only experienced in the complexity of chip on and chip off systems, but also an expert that's able to preserve that data for other experts to be able to review it. That's not an easy thing to do.
Fair enough. And Joe, in this retrial, it's becoming clearer that there's going to obviously be some different tactics being used, but both sides know what's coming now. Right. And I think that's important in this case. And there are some real issues, as we saw, for the state in their case, including, Detective Proctor, just to name one. Who has an advantage in this retrial, in your estimation?
The defense always has the advantage in a retrial because here's why. Anytime you start a trial.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. 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 I think we got a super dad. I think we got a super dad.
Here we go. Charlie Lynn, thank you so much. Exactly. All exculpatory evidence so far has disappeared. The Sallyport library and ring video. Yeah, none of that has come up yet. Everything, it's a clean slate, this retrial. But the fact that it's even a retrial is bullshit. Yeah, by the way, these dirty bastards are under investigation. Exactly. So this guy was just saying that a retrial is an advantage for the defense.
Because of the discovery process. You pretty much know from the defense what's coming at you from the state. And then you do your trial number one, and the state sees what the defense is. But I still think when you get to trial number two, the defense knows all of the state's theories. They know all of the discovery. They've seen all of the evidence. They've seen how it's played into the jury. So I think they have the upper hand. Additionally, the defense and the prosecution is agreeing, it seems that they are agreeing to release, at least partially to them, the information or the transcripts when they had at the bench conferences. I mean, I think that's just, the tip of the iceberg. I think that if the judge releases it to the attorneys, sooner or later, it's going to be publicly released. And I'd love to read what those are.
Yeah, that's going to be a little bit of a problem. We're going to get into that a little bit later in the hour. Right now, I want to go back inside that Massachusetts courtroom. Here, Karen Reed's attorney is arguing the defense needs their expert to be present when the testing is done on that Lexis information system. They point out that the state's expert from the first trial used outdated software and that was only able to retrieve about a third, as I said, of the available information, possibly, at least according to the defense, excluding evidence that could have been helpful to them. Let's go back in.
It doesn't mean that the data is.
Yeah, I agree. I think that Hank Brennan absolutely read the federal report.
Is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm going to use some made up numbers, but let's say there's 5,123 bits or bytes on a particular chip. You can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2-micron chips and the span.
I love the trolls. By the way, Mark Bederow, you win handle of the day. That's actually pretty good. But unfortunately, you're retarded. It says here you're saying Logic 101. Okay. If Morrissey was afraid of the feds, he would dismiss the case and or resign. Actually, no, because he is afraid of the feds. The only reason, if you read anything, such as a motion to dismiss and disqualify Michael Morrissey, dismiss the case, dismiss the charges and disqualify Michael Morrissey's office from the case months and months ago, then you would know that the reason why Michael Morrissey is moving forward is this is the only way that he can get the feds, he can justify the way that he conducted the investigation into the murder of Boston police officer John O'Keefe. That's the only chance that he has to validate himself is if he gets a win. If he resigns or dismisses the case, that is concession. He's conceding. Okay. And that's basically an admission of guilt. So therefore, that's why he has not resigned, and that is why he is not dismissing the case. So yeah, you're welcome to be in here because you might learn something. Unless you are absolutely retarded, which means willfully ignorant. And if you are willfully ignorant and or retarded, then, you're welcome here because you might learn something.
Expansion chip back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert be obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
You think Scott McGinnis? You think that Bev wants to have angry sex with Alan Jackson?
Mr. Jackson, I know you can do better than that, Mr. Jackson.
I need to be in detention. Mr. Jackson, faster.
All right. Any response, Mr. Brennan?
The defense expert would not be working with Mr. Burgess. He'd be observing Mr. Burgess.
God,
the defense expert has no
I have the best worst chat ever.
active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto.
If AJ's watching right now, man, he just chucked his lunch, dude. Like he just like threw it in the garbage. He was like, fuck this. It's like, ugh, fuck. Thanks a lot, Clara.
No power during the process that will delay things. It has no role and no purpose in it. And so inevitably, Mr. Burgess is well qualified.
Stop it. Y'all are terrible.
And so get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It'll provide the information that will be available to both.
I bring in the right software and the right
us and the defense.
All right. So if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate.
And I'm going to bring all my glasses and my shoes with me.
That's too far out. I want it done before Thanksgiving because time is of the essence. And I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule. So I can't give an exact date because that conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right. This one I will act on very quickly.
Listen to this guy use words like tolerate, man. I love that shit. We're not going to tolerate it, Your Honor. We're not going to tolerate it. No tolerance. We don't have any more tolerance, Your Honor. We're not going to tolerate it.
All right.
All right, what we're going to do now is squeeze in a quick break. Coming up on Court TV, both the defense and the Commonwealth want Karen Reed's second trial to be delayed. But the judge is not too keen on the idea of pushing the retrial from January to April. The line of questioning is straight ahead. Keep it here on your front row seat to justice. Hearing Michael Ayala. Now back to Massachusetts, where Karen Reed returned to court this morning for a motions hearing ahead of her murder.
Hey, this guy's all right so far, isn't he?
Retrial. 44-year-old Reed is accused of backing her SUV into her boyfriend, John O'Keefe, and then leaving him to die on a snowy road in 2022. She claims she was framed in a widespread cover-up by law enforcement. That first trial ended July 1st with a hung jury. Her team is trying to convince the state Supreme Court to drop some charges ahead of the second trial. Oral arguments were presented to the justices last week. Attorneys, along with the defendant, were in court today, arguing a joint motion for the trial to be pushed back to the spring. Now there is a new special prosecutor on the case, Hank Brennan. You saw him talking earlier, and that he's really given the state's reason now for asking for more time to present the case. Now, they both agree. They both want more time. Now, the judge still wasn't too excited about that possible delay. So let's go back into court for more of that hearing.
So I think that just leaves us with the motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
Should I begin?
Yes.
Okay.
May I begin? I'm just the girl of the world gifted 5 memberships. Oh my goodness.
And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more
Top CPU. Fuck you.
time, and I appreciated that their request was reasonable. I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony, and they're retaining experts to counter that testimony, and then to reciprocate in discovery where days, weeks are in the midst of trial. I want to.
This is the funniest shit in the world, dude. Like fucking poor Tom, dude. Tom's out there every single hearing, dude, documenting. Like, you know how important what Tom is doing out there is. Like, he's out there documenting like how fucking chill everyone actually is, how caring and how passionate everyone is, and yet how respectful everyone is in support of Karen Read. It is vital what he's doing, considering the shit that mainstream media is throwing around about the Karen Read support, right? And Tom's already been fucking knocked down. He's been knocked down. He's been pushed. He's been cussed at. Dude, fucking Bill Daniels' lawyer was like, fuck you. Dude is like 98 years old, bro. That guy's like 1,000 years old, dude. Fucking, he's like, fuck you. Then fucking and then Jim Ferris fucking has to fucking check his ass from behind. Like, what an asshole. Poor Tom, dude. People need to start showing Tom some more fucking respect, man. That shit makes me mad, but like, it's funny as fuck at the same time, dude. Like, Tom is just so cool about it. Oh my god.
To avoid unfairness to the
That's against the law what you're doing. What? Good morning? Fuck you. Tom's responses are the best.
defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates numbers, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution, so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements.
Shut up! Oh my God, I don't care!
Jesus Christ, for real, dude. I mean, fuck.
Oh, here we go.
I think we got a super chat. think we got a super dad. Super dad. Super dad. Super dad. I think we got a super dad. I think we got a super dad. I think we got.
We need to GoFundMe for Tom. Military gear needed Virginia, right? Oh my god, that's so funny, dude. Oh my god.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. I think we got a super dad. I think we got a super dad.
Oh Jesus.
So that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can
Shut the fuck up, you cunt! Shut it!
see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it. I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case if you allow this motion, I think it will make for a shorter, more effective, efficient trial. And I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right. Who's going to argue this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the time frame, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts depending on what the testing.
Have you been working on that, though, in anticipation?
We have,
okay.
Yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into a trial. And we're really trying to avoid that this time. It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery.
Mr. Yannetti, I don't really care what's fair to Ms. Reed. You've been present this entire time.
Into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests.
Joe, flip ahead.
It's all right. We'll step aside here, take a break. Coming up on Court TV, the judge questions both the defense and the prosecution about what is needed to move the case forward. Defense wants to bring in a dog bite expert to speak to the marks on victim John O'Keefe's arms, just as they did in the first trial. Find out what the judge has to say about the Daubert hearing and the joint motion to delay the murder retrial. That's next. So keep it here on Court TV.
Tonight on today's biggest tonight at 8, you killed your parent. Season finale 5.
Trial of Karen Reed. So let's hear the judge's response to that joint proposal to change the January trial date to April.
What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions that we have. So we need to start moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
We have not yet drafted the motion, but I've given it much thought. The government at trial called a expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine. All right.
That expert, I do not believe, followed the proper methodology.
What a fucking slacker, dude.
Or had the expertise to make.
All right. Does the defense intend to call Dr. I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
I expect that she will be on our list.
All right. So why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
It's like, do your job, dickhead. Like, we know you ain't got nothing better to do. You ain't doing nothing. Stop it. Just watch the fucking trial. You're not even doing nothing right now. Dumbass. Or don't, even better.
Your Honor.
Okay. So why don't we set a Daubert hearing? I know you'll have to fly her in, but why don't we get a date now in December for that?
Does the court anticipate that being a different day than the date we're going to set for the Rule 17?
Rule 17 we're doing as soon as possible. We'll do before that date.
Understood.
So we're going to need. Maybe we can have a file another 25th.
So, Mr. McDermott.
May I approach Mr. Brennan for a minute?
Sure. Jim, can you pull up to Jimmy? How was it's December 10th. I think we moved both our trials yesterday.
Would the 13th of December be available for a Daubert hearing? It's a Friday.
Possibly. I think we just put something else on this morning that would be time consuming.
I could also do the 12th if Mr. Brennan's available, and my co-counsel.
I was looking at the 10th, but Jim, could you look at the 13th?
Yeah, this is the 10th.
The 10th work for both of you.
Here we go.
The government's available on the 10th.
Here comes my favorite part.
So I have a, you cannot do the 10th, okay.
Your Honor, just to be completely candid, I have nothing on the 10th. I've got to fly out on the 11th, and I've got an all-day hearing on the 11th. So, I'm sorry, I'm reversing that on the 9th. I didn't fly out on the 9th. And I've got an all-day hearing on the 9th back in California, so I can't fly that day. So,
court ends at what time?
I'm sorry, Your Honor?
You can take, a lot of people take a red eye, right? Can they come out then?
I do every time.
You serious?
You're a magnificent cunt.
You can't fly out on the 9th, the evening of the 9th?
There's no way.
You can't fly out in the night? You can't fly out in the night?
I can't take a flight on the 9th.
The evening of the 9th?
There's no way. I can't take a flight on the 9th.
What about the 16th?
You can't fly out on the 9th, the evening of the 9th? You can't fly out on the 9th, the evening.
Time.
And fly out on the 19th, baby.
You can't fly out on the 9th, the evening of the 9th.
There's no way. I can't take a flight on the 9th.
What about the 16th? It's a Monday. Is that
We're fully booked that Monday and Tuesday.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available. All right, and all the other motions are taken under advisement.
Great.
Okay, thank you very much.
Thank you.
Yeah, sentencing can be, scheduling can be a struggle. There's no doubt about it. So the judge did not immediately issue any rulings on that request or the other issues discussed today. However, she did schedule 2 future court proceedings. The parties are expected to return on November 26th for arguments about evidence requests and on December 12th for a hearing about whether the testimony of a dog bite expert retained by the defense is admissible in this case. All right, let's bring back in our guest, joining us, trial attorney, former public defender Gabrielle Higgins, and criminal defense attorney and former prosecutor Joe Tamburino. Joe, I'll start with you, and I'm going to go back to the request by both parties to push the trial ahead a couple of months. They make cogent arguments. I mean, both sides are sort of on the same page, and the whole thing is about the interest of justice, right? At the end of the day, a fair trial. And what do you think the judge might do there? It seemed to make sense to me. I understand she wants to get things rolling, but the arguments seem to make sense.
Yes, I agree with you. And I think the judge will grant the continuance. I don't see why she would. It's not like they're requesting a continuance to next year, like, September of 25. And notice she tipped her hand a little bit when she said, it's April 1st. You're not going to request anything further than that, which signifies to me she's going to do it. She's going to set an April 1st date.
Yeah, and Ed Genetti basically said, look, we're not going to ask for any more continuances. And I think
dude must be new here. I think she'll grant the continuance. Dude must be new here. Like, I don't see any reason why. Dude, it's Bev. That's the reason why. It's Bev. That's why. And then that date's going to come and she's going to be like,
thank you all for being here. April Fools, go fuck yourselves. Did you catch a red eye, Mr. Jackson?
Oh my God.
Oh, here we go.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think.
Tom CPU, thanks, buddy. Carrie supporters, you are hands down the best people. I love and respect and admire the support for Karen's innocence. Ignore the noise, focus on facts. Well said, Tom. Thank you so much, buddy. Appreciate you, man.
I think that assurance sort of put them over the hump there, if there was a hump to get over in the first place. I want to go now to this Daubert hearing, Gabrielle, the idea that we saw in the first trial. And I thought it was to great effect. The state brought in a dog bite expert to talk about the bites, or don't let me call them bites, of the cuts that were on the arm of the victim in this case, talking about for her.
Yo, this guy's awesome. This guy's like, yo, I'm going to slip in my little passive aggressive bullshit too. Julie Grant could do her bullshit. I'm going to do mine. My man was like, the bites on John O'Keefe's arm. Excuse me. The cuts. The cuts. You saw how he just did that? I love it. I love it.
State brought in a dog bite expert to talk about the bites, or don't let me call them bites, of the cuts that were on the arm of the victim in this case, talking about for her, and she was some sort
nice try, homie.
Sort of expert, that they look like dog bites or dog scratches or some combination of the two. The state had an issue with it. They have an issue with it now. There's going to be a hearing to determine whether she can testify. What do you think might happen there?
He fucking totally knows her dog.
I think the state mentioned there were several issues with the methodology used by this expert, and I think,
dude, anybody who says that those aren't dog bites at this point, dude, is fucking retarded. Like, seriously, like just that's it. Like, just fucking get an easel and a fucking thing and watercolors and just stand in front of the window and paint what you see outside as best as you can to keep yourself from licking the window. Just do it, because that's it. Like, if you at this point do not acknowledge that these are dog bites, then you're fucking retarded.
I think that's what's causing the frustration or the need to potentially evaluate the efficacy of this particular expert. I think dog bites are one of those things that are open to interpretation, open to different perspectives. I think whether or not the jury believes that these were caused by a specific dog bite or something else is going to be up to them. I wasn't particularly moved the last time around, so I'm interested to see what the new approach is.
Yeah, it's interesting. I think it's basically, she said Dr. Russell again, or the defense said Dr. Russell will be testifying. Joe, what did you make of her testimony the first time around? I remember thinking, she didn't come across as that much of an expert. She had dealt with a lot of dog bites in emergency rooms and things of that nature. I thought she came across as someone who knew what she was talking about, but like Gabrielle, it didn't move the ball that much for me.
I agree. It didn't move the ball that much. And additionally, you know, when you look at, let me just backtrack a little bit. Even with an expert, jurors can use common sense, and they can evaluate that expert's testimony with what they actually see. And quite frankly, when you look at the scratches and the cuts on the decedent, on the victim, I mean, to me, they don't look like dog bites and dog scratches. I've seen dog scratches. I do dog bite.
Bro, how is it that they don't look like dog scratches and dog bites if you've seen them before, dude? How is that even possible?
I'm retarded?
100%. I agree with you.
Cases in our personal injury part of our firm, and they just don't appear that way to me. So I don't think that she moved the ball much in the first trial.
Yeah, I agree. The only problem I had, Gabrielle, with those injuries was I didn't know where they came from. I mean, based on the theory by the state as to how the car or the Lexus would have hit the victim in this case, I was wondering where he got the scratches to begin with. Maybe some animal came by while he was laying out there in the snow. I don't know. That was the big problem.
You know what I mean? This guy he's not letting it go. His common sense is just dictating to him, like, I'm not going to sit here and act like those are not fucking animal bites. Some way, shape, or form, I have to put it out there that this has got to be some sort of animal in some way, shape, or form. This is not fucking done by a goddamn taillight. I don't want to hear that shit. It's ridiculous. It's ridiculous. It's asinine that those injuries were caused by a taillight. And everyone who acts like Karen Reed is guilty knows it. They know it. There's no scientific explanation that would explain those injuries being inflicted on John O'Keefe by a taillight or a broken taillight. There's just no way. If he was clipped, like there's just no way. Like you know it. Like any there's no way for them to explain that coming from a taillight or Karen Reed's vehicle without sounding absolutely ridiculous. And I mean, give me a break. Dude, like, okay, they don't look like dog bites. Well, what the fuck do they look like to you? You realize that you're sitting up here on national television talking about how this case is about a woman who allegedly killed her Boston police officer boyfriend by hitting him with her SUV. And if you're familiar with the first trial, since you're an expert up here talking about the case, then please enlighten us as to how John O'Keefe got those injuries, if not for an animal. And do it without sounding stupid. I dare you. I dare anybody who's not plebeian to go on court TV and try to explain those injuries without sounding like a fucking blithering idiot.
Problem for that, and that with that bit of evidence for me.
And I think that's why the accident reconstructionist, to me, is so critical in this particular case, right? We need to know not only the chronology of how this happened, how the decedent ended up where they were, but also we need to understand positioning and where they would have needed to be for them to have those types of injuries if those injuries came by way of the car and being run over. So I think that the focus is going to be on the accident reconstructionist, less so on this dog bite.
Yeah.
I mean, she's right in the sense that, like, okay, it's on the prosecution to prove how he got those injuries. There's no way to do that. As I just explained, there's no way. So as soon as the prosecution tries to explain those injuries, they're going to sound like assholes to that jury. They're going to sound fucking stupid. There's no way around it. There's no escaping that.
Yeah, I agree. I think that's going to be the central part of this case. Again, so many things about where he ended up and how things happened just didn't make sense. And the state didn't have a cogent theory as far as I was concerned. Anyway, all right. Gabrielle Higgins, Joe Tamburino, thank you so much for being with me tonight.
All right. All right, folks. So Turtleboy, his attorneys, Tim Bradel specifically, filed a motion for all of Michael Morrissey's tech because it's all discoverable. He fucked up by using and they want to subpoena Apple for all of that data. Anything that was used through his iCloud account, they want access to it. And it's discoverable. So we got to think about this on levels of why Bederow is dope as fuck and why Bederow teaming up with Bradel is dope as fuck. Because now what they're doing is they are basically on the cusp of possibly, likely even proving Michael Morrissey's dirty shit involving the Sandra Birchmore case as well as the Karen Reed case, and not just Turtleboy's case. So this is going to be interesting. And all of that stuff, once it's discoverable, that's it. Once Karen Reed's attorneys get a hold of that, it's over. Say bye-bye to Michael Morrissey. And it's a beautiful thing, and I love it. I'm here for every second of it. I can't fucking wait. But guys, you guys are absolutely fantastic. I am going to wrap this up. Thank you guys for hitting the like if you haven't already. It really helps me out if you do that. I really, really appreciate it. And thank you guys for subscribing. If you're new subscribers, thank you guys for hanging out with me. If you've been subscribers, thanks to all my mods. You guys are amazing. People, thank you guys for all the support. I am blown away. Thank you guys so much. I'm glad you guys like the new super chat dance. Yeah, I love you guys very much, and we will do this again very soon, my friends.